To a 7-minute round. Mr. Lukiski, you're first.
Thank you very much, and thank you, Mr. Côté, for being with us here today. I think I want to start my line of questions or dialogue with you, at least, on the on your role as an independent commissioner. Currently, and correct me if I'm wrong, but my understanding, just taking a look at the org chart, you right now are, in effect, an employee of Elections Canada, are you not? In other words, you report to them. They have the ability, if they wish, or the Chief Electoral Officer has the ability to fire you. Is that correct?
It is not correct, Mr. Chair, in the following sense that I am not an employee of Elections Canada. I have a special appointment made pursuant to Section 509 of the Act, and the Act calls for me, as I mentioned in my opening remarks, to see to the enforcement of the Canada Elections Act, and in the exercise of that mandate, I act in a manner that is totally independent from both Elections Canada and from the Chief Electoral Officer. I have been in the job for 20 months, and since then there has never been any attempt by the CEO, by elected officials, by political parties to interfere with my investigations or to influence how they unfold.
Yeah, I understand that. I'm trying to get a sense of the structure, the corporate structure here. So then who has the ability to hire you or dismiss you?
The appointment is made by the CEO.
The Chief Electoral Officer?
Yes, indeed, pursuant to Section 509 of the Act.
And dismissal, if that happened?
Well, I think the general principles of law that would apply would be that he who has the power to appoint has the power to dismiss.
So, but even though that is the case, you're saying that he is not, in effect, your boss. You don't report to him.
Absolutely. It is absolutely in my mind.
I'd always, and I'm sorry, but I'd always gone on the principle that if someone can hire me and fire me, then that person is, in effect, my boss. But I'll take you at your contention. I guess why I'm trying to get at is that Bill C-23 would make you truly independent. In other words, the Chief Electoral Officer now can direct you to investigate a certain case. The C-23 would give you full independence. The Chief Electoral Officer, for an example, could request an investigation be conducted, as anyone else could request an investigation, but you would have the full authority to investigate based on your own decision, not a directive from someone else. So I think that increases and enhances your independence, which I would think would be a good thing. Particularly, and I don't know if this has ever happened before, I honestly don't, but theoretically, since the Chief Electoral Officer has the ability to appoint and dismiss you, as you mentioned, what would happen if, in fact, there was a case where you felt you had to investigate an employee of Elections Canada? Would you not think there would be a conflict there?
There is a lot of in that question, Mr. Chair. I'll try to attack it in bits and pieces. So the Chief Electoral Officer does appoint the Commissioner, but in my sense, he's not the boss. And an analogy to this would be like the government appoints judges, but the government is not the boss of the judges. Once the CEO has appointed the Commissioner, then the Commissioner is responsible, and he alone is responsible for enforcement of the Act.
Can the Chief Electoral Officer direct you to conduct an investigation?
He could refer a file to me and direct to me that I should investigate it, but then how I do the investigation, how far I go with it, what I do with it, would be entirely within my purview.
But it would still be his determination that an investigation be conducted, be initiated, right?
Well, he would say to me, please look into this, investigate this. I would say, thank you very much. And then I would, with my Director of Investigations, decide how I was going to investigate that.
Would you be able to refuse his request or his directive?
Well, the CEO is an agent of Parliament, and my presumption would be that if he refers a file to me for investigation, he probably has good grounds to do that.
Okay, but under C-23, and this is the distinction I'm trying to make. I'm certainly not trying to be argumentative here, but I think it's an important distinction. Under C-23, you would not be directed by anyone. It would be your decision and your decision alone if you wished to conduct an investigation based on a complaint or if someone requested, but it would be your decision. Currently, you're suggesting, you're saying to this committee that the chief electoral officer, if he directs you to conduct an investigation, you will. You may conduct it in your own fashion. That's great. But you have no right to refuse.
Well, there is an act of Parliament that specifies the circumstances in which the director of the chief electoral officer may ask me to conduct an investigation. So Parliament has spoken and has said that this is the way it should be. And again, I think it's very important that if the CEO does that, then I decide how I'm going to do that, in the same way that if Bill C-23 is passed as it is now, if our office were to move with the office of the DPP, in the same way, I would decide how investigations are to be conducted.
And my question about what would happen in the event that you ended up having to investigate someone in the chief electoral office itself, would there not be at least a perceived conflict there, since the chief electoral officer himself, as you admitted, appoints you and can dismiss you?
I don't think that there would be certainly any conflict of interest, and I'll tell you a couple of things.
I mean, you stated in your brief that one of the reasons you don't think it would be appropriate to be housing your office with the DPP is a perception that there might be some conflict. Do you not think the same perception would be created if you were investigating, or if you were to investigate an action by the electoral officer, and he in fact is in effect the one who can hire or dismiss you?
At least two things on this. One is I certainly would see any cases involving an electoral officer or an employee of Elections Canada where fraud or misbehavior of some sort was alleged as being a very serious matter. And I can assure you that as Commissioner, this is something that I would go to the bottom of with all the energy and all the tools that I have at my disposal. That would be point number one. Point number two, there is a lot of benefits, as I think I alluded to in my opening remarks, in our being now part of Elections Canada. And it has to do with the day-to-day operation. It's very important for us as Commissioner, as enforcers of the legislation, to understand the priorities, to understand the environment in which decisions that we take have to be taken. We cannot operate in a separate world, in a separate planet. We have to have that access. Secondly, and more importantly, if Bill C-23 is passed as it is now, there will be serious issues that will come up in terms of what information the CEO may communicate to me as Commissioner. Right now, we are both within the same organization, so the flow of information is free and it goes quickly. If I am to move into a different organization, which now would be a department of the government, there will be all kinds of issues having to do, for example, with privacy, with personal information, in terms of whether or not the CEO has the power to disclose and communicate that information to us. And certainly this is an issue that should be addressed, because that kind of uncertainty would create no end of problems and headaches. And I would put it to this committee, Mr. Chair, that this is a very important issue. There has to be clarity in the law in terms of what the CEO can communicate with me if Bill C-23 is passed as it is, and also in terms of what I may request of the CEO. And I would go one step further. It seems to me that there should be a provision in the bill, again, if it is passed as it is, which would compel the CEO to respond to any request I make for information and to give me that information in the same way, for example, that Bill C-23 provides that with the new scheme that might be created, the CRTC would have to disclose to me any information that I requested of them in terms of the new scheme that is being created for voter contact.
Thank you very much, and thank you, Mr. Lukiski. But we went quite over time there again, so let's try and